And for the next session, we will talk about fraudulent trading in Malaysian company law context. And I would like to invite Miss Sia Siew Mun and Mr. Nguyễn Công Phú. Miss Sia Siew Mun is the founder and managing partner of Sia Siew Mun and Co. in Malaysia, and she is a senior litigation lawyer and has been experienced for more than 20 years. Miss Sia Siew Mun has been involved in various complex litigation matters and has been appeared in all levels of Malaysian courts. So now the stage is for you. Thank you.
Thank you. Good afternoon, Ho Chi Minh. Greetings from Kuala Lumpur. Thank you for having us and giving me the 15 minutes limelight to share with you what I understand to be the fraudulent trading in Malaysian context. Now, Mrs. Stephen has shared at length how the Malaysian courts work. I will reiterate just a little bit in the context of Malaysian company so that you can then understand what's the relevance of our Malaysian company law vis-a-vis English law. How do I control? So this is management of expectation so that you know when I'm starting and when I'm stopping. So I have 7 headings and I will start with Malaysian company law to tell you how courts actually look at what is the law vis-a-vis the company, the members, the shareholders, creditors, contributories. And item number 2 and number 3 can be taken together to explain to you the structure as far as the Malaysian company law is concerned. I've been prompted, I've been tipped off by Hai to quickly go into this because it's actually very similar to Vietnam. But I'll still touch on it nevertheless, because that lays out the platform to the exceptions that I'll be talking about, which I suppose that's the main highlight. So exceptions to separate entity, to manage your expectation again, the topic will be limited to what is set out by the company's law. But I want to highlight that there's also a common law. Company's law is written law, and the common law is actually the unwritten law, where it's by customary and tradition has been laid out to be the law that governs the company law. Then the piercing results in personal liability. And then I'll highlight 2 judgments that is interesting from the Malaysian judgment and conclusion to where this topic is leading in Malaysia. So very quickly, this is the big bubble about what governs Malaysian law. The Malaysian Companies Act is slightly big in bubble because that is the main thing that actually governs the Malaysian company law. But there is also a small bubble, which is common law, which is the unwritten law. So basically, we go back in time, look at what are the previous judgments given by the courts, how they have set out, what are the duties owed by the directors, etc. So, but there are, of course, other acts and legislations as well. But just to highlight to you that these are the 2 things, written and unwritten law. I've laid out this timeline so that you can understand the origin of the Malaysian company's law. Malaysia's timeline is set out at the bottom in red, Australia on top. Now, actually the highlight is UK, not Australia. But I've set out Australia only because Malaysia adopted the Australian model, but the Australian actually adopted the UK model. Yeah. So, but along the way, as the company, as the nation progresses, there will be reforms, there will be amendments to suit the environment of the respective countries. But by and large, we are still largely influenced by the UK and the Australian model. So even though by 1981, Australia has actually morphed into quite a complicated, quite complex code for the company law, from time to time, we will still look at UK company law, look at the Australian company law to see whether their codes actually have similarities in the codes. And when they are similar or dissimilar, those will be actually highlighted in the court when you submit on how to integrate these relevant sections. Yeah. So I've established the relevance of the Malaysian law in bigger context, Australian and UK law. This is where I've been tipped to go through it very quickly. Essentially, you can see 2 vertical rows, company being in the middle, but essentially to highlight shareholders own the company through the shares. They have objectives that are quite they're not similar to the objectives of the directors. Now, why? Because directors have the overriding duty to act in the best interest of the company. So even if it's not in the best interest of shareholders, their ultimate duty is to act in the best interest of the company. So there are 3 persons, essentially a threesome here, relationship, which is the member, the director, and the company. Now, Hai has mentioned, but what if the director is merely an employee? There are also situations where in smaller companies or where you have owners who want to have larger control of the company, what they'll do is they ensure that they themselves are appointed as directors. But the duty is still the same. The director, who is also the owner, when making decisions for the company, has to put the company first, not the shareholders. Now, the reason I highlight this is because under company law, there's actually no distinction whether you are the owner director, whether you are an employee director, or you're a sleeping director. The law is the same, the obligation is the same, overriding duty is the same. I borrowed this picture, credits have been duly given at bottom right. So it's to highlight the separate legal entity concept. Here, they only show the members, but in reality, there's also the directors. So it's not just about the members and company, the directors. Technically, they are protected by the veil as well. Okay, so now the highlight. Exceptions to separate entity. Okay, it's very relevant in the modern context because, especially in Malaysia, I don't know about Vietnam, you have a situation where the company enters into a contract, large or small. The creditors enter because they feel like, oh, this company has been around for a while or whatever. But at the end of the day, when disputes arises or when contracts are not honored, damages arises, you go to court, you get a judgment. Yay. But in Malaysia, 9 out of 10 times, it's actually a paper judgment. And what does that mean? It means that you only have judgment in your favor where you can tell the tax people, the auditor, that you can write off the sum as a receivable in your account. In reality, you can't collect single cent. So you have a situation where the separate legal entity concept is actually abused because people like to hide behind a limited liability company to transact, to invest, to carry out operations. And when things don't go well, they just abandon ship. And the creditors are left with nothing but paper judgment because there's nothing else left in the company. And the separate legal entity principle protects it. And in fact, in the UK, I was just revisiting the trends in UK recently. They still hold on to this separate legal entity and apply it very, very strictly. While there are exceptions, the way they look at exceptions is really in abnormal circumstances do they then allow exceptions for you to pierce and transfer the liability to an individual, be it the member or the director, depending on circumstances. So what is important for people who transact with limited liability companies is to know that there are exceptions, and the end result of this exception is that personal liability will be attached beyond the limited liability company. So I now move to the concentrated, limited scope, which is under the Malaysian Companies Act, which is also similar to Singapore, one largely similar with the UK. I want to highlight two possible offences that might trigger personal liability on the directors. Yeah? This is not on the members, this is on the directors. So directors who are employees, directors who are used to taking instructions from members, the shareholders, and directors who are sleeping on the job will want to know that they could be held personally liable for the company's debts under two situations under Malaysian companies law. One is wrongful trading, and the other one is fraudulent trading. As the name suggests, fraudulent sounds more serious, and it is more serious in terms of the effect and the liability. So this is where I have summarized and distilled elements. I've pitched it against each other so you can see what's the difference. Left side is wrongful trading, right side is fraudulent trading. The individuals want to know that if you are found guilty of wrongful trading, you are found to be personal liable, so it's fraudulent trading. But what's the big difference here? On the wrongful trading side, the director will be found, will be asked to be liable for whole or any part of the debt. So it's a specific debt. Whereas under fraudulent trading, it is for all, equally for all the company's debts or liabilities. Now, in short, it basically means that if you con $1, you could be liable for $100 or whatever the liability is for the company. Yeah. So now I want to zoom in on wrongful trading. Why? Because all of us have just survived COVID. And I think during the COVID period, many directors have run foul with wrongful trading offenses. Why? Let's take a look at the elements. The element says it's a wrongful trading when the director knowingly contracts a debt when there is no reasonable or probable ground that the company can pay the debt. So now during COVID, there's a lot of shutdowns, business sliding, and there will be probably very gung-ho directors who feel like, no, can do this, let's get the goods in, let's enter into a contract. I don't have the money yet, but I'm sure we'll be able to take this. So overly optimistic, overzealous directors may enter into a contract when there's no reasonable or probable ground the company can pay the debt. So under this sort of situation, if an action is pursued and the company can't pay, and in fact, in tandem, they can actually go after director and say, you pay up. Now, certain countries, like Singapore, has actually enacted a statute to give the director a get out of jail free card during the COVID period. Unfortunately, in Malaysia, we don't have that protection. So technically, any transactions that's taken place during the COVID period, if these elements are satisfied, would still trigger a personal liability. Okay, now we move on to two court cases that I just want to highlight. This is a decision by the apex court of country, i.e. top. So even if you don't like it, it's too bad. That is a law. Okay. So the factual matrix of the case, what I want to highlight is Centennial is the company where the directors were eventually found to be personally liable. Okay. So the focus is on Centennial, the oval bubble in red words. Why I want to highlight is you will realize that the modus operandi for this company is actually quite similar to many other investment companies. So there is actually essentially a $2 company vehicle, special purpose vehicle, to acquire the logging rights. Then we use another company, which is also a shareholder of the $2 company, to make the payments. So basically, in the SPA, there is agreed consideration of $7 million to be paid. And you will know that it's not a situation where Centennial intended to get the logging right and not pay a single dollar on day one. In fact, at the bottom here, there's a note to say that they have actually paid $2 million. They have paid another $2.5 million. In total, they paid $4.5 million, and they could not pay the final $2.5 million. Fast forward, federal court said, because of the way you set up the companies, firstly, the contracting party is almost a sham, it's a shell company. Take a look at the green box on bottom right. It says one of the factors taken into consideration by the federal court to penalize directors is to say, look, it's a dormant, no capital injection. But isn't that very common for most investment companies? Then number two, the rights were transferred to individual. Now, this is where it's a bit peculiar because we are in the adversarial system. So courts will normally take into consideration of what has been raised and debated or submitted by the respective lawyers. So rights were transferred to the individual. Now, the rights initially belong to Faith, which is a partnership. It can't transfer its right to a company. It has to be transferred to another individual, a natural person. And it was under that circumstances that those logging rights were actually transferred to the natural persons, i.e. the directors and shareholders of Centennial. Yet it was taken into consideration to find fraudulent trading against the directors. And then the thirdly, it was payment through a different company. So long and short is that eventually the federal court basically said that this sort of circumstances basically triggered a personal liability on the director's part, where they didn't say, company can pay, but you, directors, pay the $2.5 million. Okay, so this is a federal court judgment. Another one would be from a slightly different perspective, which is about who do you pay? So when you have successfully hold a director to be personally liable, in this case, it was a law firm. They say about 5 million ringgit is due and owing to them. So company went bust, and the factual matrix was they actually had the money to pay. At the bottom, there's a note there. One of the witnesses actually said, yeah, we had the money, but gave no explanation as to where the money went, but yeah, not paid, and company is wound up. So under normal circumstances, it's a pay judgment against the company because too bad. But this is where fraudulent trading was raised again, and the company, sorry, the High Court actually said, naughty boys, fraudulent trading. You are personally liable. Now, up to that part, all is well and good. Yeah? Directors, you are personally liable. But what the High Court judge then did was to say, but the money that you owe the law firm, please pay to the liquidator of the wound company, so that the liquidator will then reshuffle the cards and decide, based on the preference of payments, who gets paid. So the judge basically dissected the UK jurisprudence on this fraudulent trading and said, I'm following the UK position to say that when the directors are found to be personally liable, they pay to the company. But what the judge did not discuss is that in UK, there is specific provision that we don't have. And that specific provision allows the court to make an order that directors pay the company. We don't have that sort of provision. So if we go back to whatever provisions we have, it basically means that the director stepped into the shoes of the company as far as that particular debt is concerned. So now, thankfully, that judgment was corrected upon appeal. You have discussed about appeal. So the High Court judge made the decision that fraudulent trading, pay the company. Then upon appeal, the law firm said, no, there's no such provision. That was corrected by Court of Appeal. It said, yes, fraudulent trading, but you don't pay the company. You pay to the law firm directly. Okay, so these are the two cases I want to leave with you. My conclusion is basically this. For the principles of separate legal entity is actually a sanctity as far as company law is concerned, to give certain protections to investors so that they have peace of mind when they invest and when they do business. But of course, that is provided they don't abuse the vehicle of the separate liability entity. So there are exceptions, but the exceptions should be only in very true and rare circumstances and should remain so, despite the fact that the general sentiment is that we're always left with $2 money. So despite those sentiments, we should still look at the law and say, does the exception trigger this situation where personal liability should be attracted? So I would say that our observations of the court these days, and based on the number of reported cases, is that the Malaysian court is now more willing to look at exceptions. You will see in the past, up until the 90s, you don't see any reported cases of fraudulent trading. But now you see more of that now. And now you see more courts judgments that are prepared to find fraudulent trading. Again, it should not be done at the expense of an application of exceptions and threshold for piercing corporate veil. Thank you.
Thank you so much. Thank you so much, Ms. Sia Siew Mun. And let's turn to the presentation of Mr. Nguyễn Công Phú. Mr. Phú is a partner in charge of firm's partner relation practice group.